nomination of Judge Ralph D. Gants to the position of Associate Justice of the Supreme Judicial Court in Massachusetts. My name is Tim Murray. I'm the Lieutenant Governor. I'll be chairing this hearing of the Governor's Council. At this time, I'd like to introduce my colleagues on the Governor's Council, beginning with Councilor Carol Viola, Councilor Marilyn Tito Devaney, Councilor Mary Ellen Manning, Councilor Tom Foley, and Councilor Tom Merrick. Dear Councilors, I'm pleased to nominate Honorable Ralph D. Gants to the position of Associate Justice of the Massachusetts Supreme Judicial Court. I submit this nomination for the advice and consent of the Executive Council pursuant to Part 2, Chapter 2 of the Constitution of the Commonwealth of Massachusetts. I'm proposing the nominee's resume for your convenience. Before I introduce the judge, just want to give people who are here a little overview of how the hearing will be conducted. Judge Gants has already submitted a witness list, people who will speak based on his behalf, who will work with him in different capacities. But everyone present, if they so choose, is going to be given the opportunity to be heard on his nomination. Also, I want to let people know that there are index cards on the front table. If you are not already on the witness list or do wish to speak at this hearing, please print your name and address on the index card and indicate whether you'll be speaking in favor of the nomination or in opposition to the nomination. Please see that your completed index card is passed to me. Mr. George Cronin is the Executive Director of the Governor's Council, is here in the back of the room if you have any questions during the meeting. In addition, there are also two legal pads on the table. They are available to those who do not wish to speak but would like to be recorded in either in favor or in opposition to the nomination of Judge Gants. One pad is for supporters, the other pad is for opponents. You are encouraged to sign on the indicated pads as an alternative to speaking if you choose. And to introduce the council, so I want to give Judge Gants an opportunity to introduce himself, and I know that he has members of his family here before we begin calling some of the witnesses. Judge, welcome.
Good morning, Lieutenant Governor, members of the council. With me is my wife, Deborah Ramirez. Her right is my daughter, Rachel Gants, came up from college very late last night. My son, Michael Gants, who's a sophomore in high school. And in the back is my mother, Elaine Gants, who a few months ago celebrated, as Jack Benny would say, the 50th anniversary of her 39th birthday.
I know that there is a House caucus shortly, so I want to give an opportunity to two state representatives who are here who wanted to speak on behalf of Judge Gants, beginning with the town of Lexington. Representative Jake Kaufman is here.
Thank you, Governor Murray.
Mr. Chairman.
Thank you, Governor Murray, members of the council. It's a joy and an honor to be before you on behalf of my friend and constituent, Ralph Gants. I know that this hearing is not, nor should it be, a political process. You are here to make some judgments about Ralph Gants' intelligence, his wisdom, his judgment, his temperament. But let me tell you a small political story that speaks to those. Ralph and I have talked about many things over the years, and what comes to mind as I stand here this morning are two conversations we had, one about the reform of the courts and the other about judicial pay. And in both of those conversations, I was struck by the homework that he had done, his ability to amass a tremendous amount of information, put it in a form that even I could understand. The way he weighed the pros and cons, the way he weighed the subtleties, the way he weighed a wealth of conflicting information and conflicting perspectives, and then the way he conveyed that with a confidence, a certainty, and a passion that was compelling. I don't think it's possible, given the English language and human nature, to do what he does as well as he does. He communicates extraordinarily effectively and is as straight a shooter as there is in the Commonwealth. I think the citizens of this Commonwealth are blessed that he has there may be people who are Judge Gants' equal. There are none that are better. And we are fortunate to have him, and look forward to having him on the SJC for many years to come. Thank you for your consideration.
The representative, are you giving us good news on the building?
No comment.
Representative Katusha.
Thank you, Governor. My name is Councilor Devaney, Councilor Viola, Manning, Foley, and Merrigan. Thank you very much. I'm glad that you asked the previous chairman that question about the pay raise. I came here to testify on behalf of Judge Gants. I've known Judge Gants now for 10 years, both personally and professionally. And I can tell you that this will be one of the best positive votes that you can make at the 3-year retired term of the Governor's Council. I know Judge Gants as a man, as a judge of 10 years. I have seen his smart, his principled work, his impartial work a great deal during this time. He's a man that empowers those around him while doing this work, but he offers his own decisions, and he makes his own decisions. He does not put them off on anyone else. He's a person that carefully researches each and every issue that's before him in order to fully understand that issue so that he can make a decision based on fact and law, not on emotion. He's a person that has this secret of great intelligence, but a prodigious work ethic, which I'm sure you'll hear about. Something that is not too common necessarily to have both. Particularly if one is blessed with great intellect, sometimes one doesn't feel the necessity to work as hard, and yet this is a man that has both to great degrees. And yet, despite his great intelligence, he's sort of a workaday ethic. Let me go to my work, I love my job, let me do the right thing, which I think is something that we should all embody in the way that we do our jobs. And I think that it's a real testament to the way he was brought up, and I complimented Mrs. Gants. He's been given great gifts, but those gifts would be nothing without what his family must have taught him about treating people with respect and dignity, and working very hard, in many ways being humble, in many ways being simple. He's well known, he's well regarded, incredibly well regarded by the legal community, and I suggest that Judge Gants is a judge's judge. A judge that all judges either should be, would be, or wish they could be. And as a man, which I think is the greatest testament to who he is, he treats all those around him with dignity and respect. He's a great teacher, he's a great mentor, he's a great man, and he loves his family very much. There's two great loves, I think, for Ralph Gants in his life. It's his family first and foremost, and his job. And I've even seen where these two great loves in his life have caused him to make choices because of the great love that he has for each of these. And I think that just the way that he grapples with how he feels about his job, about Debbie, about Michael, and about Rachel, is a testament to a great person. He's a person that I admire a great deal. And I believe that should you decide to vote for him, which I believe that after hearing him and some of the testimonies, hopefully you will do, that it'll be one of the best elections you could ever make during your tenure in the Governor's Council. So thank you very much.
Thank you very much, Governor, and members of the council. Thank you for this opportunity to appear here today. Some of the themes that you've already heard sounded by our two legislative leaders are ones that you're going to hear, I think, resonating through all of our remarks. When I charge juries, I charge them, that is at the end of the case, I urge them to decide the case without fear or favor. In other words, to render their verdict without being swayed by public sentiment or popular opinion or matters outside the case. That principle is really the centerpiece of judges' integrity and independence. No one personifies that better, I think, than Judge Gants. He is someone who, in his decisions, upholds the law and the integrity of the process. He treats the Constitution as a living document, and his decisions are very respectful of the duties and responsibilities of the other branches of government. They're also very insightful and balanced and wholly without agenda. And he is what you want every judge to be, fair and impartial, and not afraid to make the tough calls. And he's made many of those tough calls in his years as a Superior Court judge. He's a person of enormous intellectual prowess, and he is, as they say, at the top of the class with respect to his colleagues on the Superior Court. And he grapples with the most difficult and complex and thorny legal issues that we have on the court, yet his decisions reflect a clarity and lucidity of thought that make his reasoning understandable to the average person. But not just that, I mean, his decisions really show an appreciation for the struggles and the challenges of the people whose lives have been impacted by those decisions. He has served in the business litigation section now for over 4 years, his past year as administrative adjuster. And he followed in the footsteps of Judge Alan Van Gessel and has maintained the high standards of excellence in that session. And he has contributed to the standing of that session enormously, both in Massachusetts and across the nation. One example of the high regard in which the session is held is that now we see many companies, including in their contracts, a choice of forum clause that say in the event of dispute, the matter will be litigated in the Massachusetts business session. And that is really, I think, very good for business and the economy in Massachusetts. And entities like the Chamber of Commerce have, who rate these sessions across the nation, have given Massachusetts considerably higher ratings since the inception of the session, which was about 8 years ago. But that's really due to the efforts of Judge Gants and all the other judges who have come through the session. At one recent conference on business litigation, Massachusetts was referred to as the gold standard. And I think we can appreciate this more as we move into these challenging fiscal times. It's not just among corporations that the session has gotten such a good reputation, because individuals, class action plaintiffs are filing their lawsuits there because they know they're going to be treated fairly. Although his most recent work has been in the business litigation session, he has served many years in criminal sessions as well, with the same distinction. He favors neither prosecution nor defense. He holds them both to the same professional standards, and he calls out abuses of power wherever he sees them. His talents come remarkably without arrogance, and attorneys consistently give him extremely high marks for his temperament, his calm, dignified demeanor, and his respectful manner. He is grounded in his work, I think, by his involvement with his family, his children's activities over the years, coaching Little League, basketball, for example, working with his temple on Christmas Day to serve meals to the elderly and the shut-ins. And he also plays in an over 50 soccer league, which by his own reckoning is a very humbling experience. He devotes, as you've already heard, significant time to education. He teaches law school several classes. He participates very frequently in programs to the bar, seminars for judges. He's always in demand because his presentations are not only educational, but they're also entertaining, and he has a wonderful sense of humor, which is often deprecated. His courtroom is on the same floor as my office, and many evenings I see him leaving so burdened with papers and homework that he uses a public elevator because he doesn't have a free hand to use the keys and the swipe card necessary to run the judge's elevator. He churns out, on average, about 100 pages of decisions a month, almost all of which he does himself. It's an incredible feat. I have to confess that his nomination for me is bittersweet. He's going to leave a huge hole in the Superior Court. But I firmly believe that he's going to go down in the annals of the Supreme Judicial Court justices as one of the truly great. I'd be happy to answer any questions you have. Thank you very much again. Thank you. Yes.
I have a question. You said that he consistently receives high marks from attorneys. Can you elaborate for us a little bit about what the judicial evaluation process is and what you base that on, what kind of information you obtain in those evaluations and how
Let me preface by saying high marks in the evaluations. Attorneys evaluate, police evaluate, and jurors evaluate, and in all three categories of evaluators, he has done extremely well. And that's one thing that is always commented on, his intellect, his demeanor, and his knowledge of the law and his work ethic. Those are the things that not only get there, but when I go to bar events and whatever lawyers always say, they talk to me in particular about those attributes that made him an outstanding juror. Any other questions? Thank you again. Thank you, Judge.
Thank you, Councilman, for pointing out Justice Robert Cordy from the SJC has joined us, Judge. Good to see you. And a number of luminaries in the press are here as well, but I want to point out that we are making history, all of us here today, in that Lawyers Weekly is doing a live blog here from the room. So, live...
We make history every week here.
With that, we'll call Helen Foley-Bousquet, the Assistant Clerk for Civil Business, the Suffolk County Superior Court.
Lieutenant Governor, and members of the Governor's Council, it is my sincere pleasure to appear here today before you in unreserved support of the nomination of Judge Ralph Gants as an Associate Justice of the Supreme Judicial Court. As Assistant Clerk in the Business Litigation Section of Suffolk Superior Trial Court, I have been most fortunate to work with and observe Judge Gants in the daily administration of a very busy court dealing with high complex cases and law. In my 26 years as Assistant Clerk in a Superior Court trial session, I have not seen any judge with a greater dedication to a just result, with a more analytical mind or concern for the rights of litigants and their attorneys. His ability, character, hard work, legal writing ability, and dedication to the law will make him an excellent addition to the Massachusetts Supreme Judicial Court. I wholeheartedly recommend Judge Gants for position. Thank you.
Thank you very much, Governor, and members of the council. Thank you for this opportunity to appear here today. Some of the themes that you've already heard sounded by two legislative leaders are ones that you're going to hear, I think, resonating through all of our remarks. When I charge juries, I charge them at the end of the case. I urge them to decide the case without fear or favor. In other words, to render their verdict without being swayed by public sentiment or popular opinion or matters outside the case. That principle is really the centerpiece of judges' integrity and independence. No one personifies that better, I think, than Judge Gants. He is someone who, in his decisions, upholds the law and the integrity of the process. He treats the Constitution as a living document, and his decisions are very respectful of the duties and responsibilities of the other branches of government. They're also very insightful and balanced and wholly without agenda. And he is what you want every judge to be, fair and impartial, and not afraid to make the tough calls. And he's made many of those tough calls in his years as a Superior Court judge. He's a person of enormous intellectual prowess, and he is, as they say, at the top of the class with respect to his colleagues on the Superior Court. And he grapples with the most difficult and complex and thorny legal issues that we have on the court, yet his decisions reflect a clarity and lucidity of thought that make his reasoning understandable to the average person. But not just that, I mean, his decisions really show an appreciation for the struggles and the challenges of the people whose lives will be impacted by those decisions. He has served in the business litigation section now for over 4 years, past year as administrative adjuster. And he followed in the footsteps of Judge Alan Van Gestel and has maintained the high standards of excellence in that session. And he has contributed to the standing of that session enormously, both in Massachusetts and across the nation. One example of the high regard in which the session is held is that now we see many companies, including in their contracts, a choice of forum clause that say in the event of dispute, the matter will be litigated in the Massachusetts business session. And that is really, I think, very good for business and the economy in Massachusetts. And entities like the Chamber of Commerce have, who rate these sessions across the nation, have given Massachusetts considerably higher ratings since the inception of the session, which was about 8 years ago. But that's really due to the efforts of Judge Gants and all the other judges who have come through the session. At one recent conference on business litigation, Massachusetts was referred to as the gold standard. And I think we can appreciate this more as we move into these challenging fiscal times. It's not just among corporations that the session has gotten such a good reputation. Because individuals, class action plans are filing their lawsuits there because they know they're going to be treated fairly. Although his most recent work has been in the business litigation section, he has served many years in criminal sessions as well, with the same distinction. He favors neither prosecution nor defense. He holds them both to the same professional standards, and he calls out abuses of power wherever he sees them. His talents come remarkably without arrogance, and attorneys consistently give him extremely high marks for his temperament, his calm, dignified demeanor, and his respectful manner. He is grounded in his work, I think, by his involvement with his family, his children's activities over the years, coaching Little League, basketball, for example, working with his temple on Christmas Day to serve meals to the elderly and to shut-ins. And he also plays in an over-50 soccer league, which by his own reckoning is a very humbling experience. He devotes, as you've already heard, significant time to education. He teaches law school several classes. He participates very frequently in programs to the bar, seminars for judges. He's always in demand because his presentations are not only educational, but they're also entertaining. And he has a wonderful sense of humor, which is often deprecated. His courtroom is on the same floor as my office, and many evenings I see him leaving so burdened with papers and homework that he uses a public elevator because he doesn't have a free hand to use the keys and the swipe card necessary to run the judge's elevator. He churns out, on average, about 100 pages of decisions a month, almost all of which he does himself. It's an incredible feat. I have to confess that his nomination for me is bittersweet. He's going to leave a huge hole in the Superior Court. But I firmly believe that he's going to go down in the annals of the Supreme Judicial Court justices as one of the truly great. I'd be happy to answer any questions you have. Thank you very much again. Thank you. Yes.
I have a question. You said that he consistently receives high marks from attorneys. Can you elaborate, of course, a little bit about what the judicial evaluation process is and what you base that on, what kind of information you obtain from those evaluations, and how assessment of his skills as a judge?
Okay, let me preface by saying that those evaluations are confidential, but I think I can fairly share with you that he does receive those high marks in the evaluations. Attorneys evaluate, employees evaluate, and jurors evaluate, and in all three categories of evaluators, he has done extremely well. And that's one thing that is always commented on, his intellect, his demeanor, and his knowledge of the law and his work ethic. Those are the things that not only get there, but when I go to bar events and whatever lawyers always say, I talk to them in particular about those attributes because he's made an outstanding juror. Any other questions? Thank you again. Thank you, Judge.
Thank you, Councilman Manick, for pointing out Justice Robert Gordy from the SJC has joined us Good to see you. And a number of luminaries in the press are here as well, but I want to point out that we're making history, all of us here today, in that Lawyers Weekly is doing a live blog here from the room. So, live...
We make history every week here.
With that, we'll call Helen Foley-Bousquet, Assistant Clerk for Civil Business, the Suffolk County Superior Court.
Lieutenant Governor Collins and members of the Governor's Council, it is my sincere pleasure to appear here today before you in unreserved support of the nomination of Judge Ralph Gants as an Associate Justice of the Supreme Judicial Court. As Assistant Clerk in the Business Litigation Section of Suffolk Superior Court, I have been most fortunate to work with and observe Judge Gants in the daily administration of a very busy court dealing with high complex cases and law. In my 26 years as Assistant Clerk in the Superior Court trial session, I have not seen any judge with the greatest dedication to a best result, with a more analytical mind or concern for the rights of litigants and their attorneys. His ability, character, hard work, legal writing ability, and dedication to the law will make him an excellent addition to the Massachusetts Supreme Judicial Court. I wholeheartedly recommend Judge Gants for the position. Thank you.
In person, when I was presiding over the hearing yesterday, and she called back. It must have been 5 seconds because Judge Gants called me back, and you were right. I was on both phones. So
Thank you.
thank you.
Can I also, hi, I don't know if you recognize me at all. I was in front of a judge that you worked for a pretty lengthy case, and I want to say that you were a consummate professional. I got very, very, you ran an excellent session, I believe, and your opinion weighed very heavily with this attorney, and I'm very pleased to get to see you, and I know it's probably not your usual job description speaking in front of all these people, but you did a great job, and we really respect you. Thank you very much.
Thank you very much.
Introduce yourself to me as Katie, not Catherine. Katie DeSimone, the First Assistant Clerk of Criminal Business in Suffolk County Superior Court. Welcome.
Thank you very much. Lieutenant Governor Simari, members of the Governor's Council, family and friends of Ralph Gants. I can't tell you what it's honor for me to be here testifying on this matter. First of all, I ask myself, what is the Supreme Court judiciary system looking for in a man? A person with integrity, great reading and writing skills, who's good looking, someone who's open-minded, someone who weighs the evidence of both sides before making a decision, someone who does their homework and always prepared to go forward, someone who has respect for the law and upholds the Constitution, and most important, is fair but firm and honest. To me, the Honorable Ralph Gants has shown all of these fine qualities, and from my heart I feel that we are great assets to the Supreme Judicial Court, and I thank you very much.
Thank you very much.
Philip Tortorella, Squad Supervisor from ATF.
Mr. Lieutenant Governor, honorable and distinguished councilors. My name is Philip Joseph Tortorella, Jr. I reside in Duxbury. Thank you for the opportunity to speak in support of the Governor's nomination of Superior Court Justice Ralph Gants to the Supreme Judicial Court. I am a career investigator with 32 years of service in the public sector. I retired as a special agent from the Federal Bureau of Alcohol, Tobacco, and Firearms, ATF. I also served in 2 state government positions, Assistant Secretary of Public Safety and Special Assistant for Investigations to the Attorney General. In January 1984, I was a supervisor of an arson task force in Boston. The Assistant United States Attorney who handled arson prosecutions was a talented prosecutor, Mark Robinson. The focus of our investigative efforts was a series of nighttime fires that had plagued Boston and the surrounding communities in 2 years. The fires were the subject of major news media coverage and caused Boston to be labeled the arson capital of the world. The scope and complexity of the investigation prompted the United States Attorney to assign a second prosecutor to the investigation, Assistant United States Attorney Ralph Gants. In short order, Prosecutor Gants impressed me with his knowledge of the law and his attention to detail. In addition, he's demonstrated several other traits that were admirable: his sense of duty, his concern for the victims, and a genuine respect for the contributions made by the investigators. Prosecutor Gants reviewed each and every piece of documentary and physical evidence before he helped craft indictments, charging the 8 defendants for setting 269 arson fires that injured 383 firefighters and caused property damage in 1982 and 83 terms in excess of $50 million. Prosecutor Gants was particularly motivated by the Boston firefighters who sustained career-ending injuries when they fell through the roof of a building on E Street in South Boston. When the investigators uncovered plots hatched by the defendants to eliminate me and murder several witnesses, Prosecutor Gants helped ensure that the proper legal action was taken to prevent the defendants from acting on their plans. When the mother of an investigator passed away, Prosecutor Gants went out of his way to attend the out-of-town funeral, even though his car broke down en route. Ultimately, the 8 defendants were convicted in federal court and were given prison sentences ranging from 5 to 40 years. In April of 1985, Life magazine included an article about the men who tried to burn down Boston. You may find the picture of Prosecutor Gants interesting. The caption under the picture identifies him as United States Attorney William Well. After the last conviction, Mark Robinson moved to another unit in the United States Attorney's Office, and Prosecutor Gants became my primary contact. For the next several years, we worked together on a number of investigations. Prosecutor Gants consistently impressed me with his sense of duty. When we were on heightened alert because of bomb threats directed at Boston Garden, he stood by with us late into the evening, just in case. When the case agent was unavailable, Prosecutor Gants volunteered to accompany me on a visit to a prison to interview a potential witness. The man had previously expressed an unwillingness to cooperate with the government. I sat there while those prisoners in that particular institution that night, and it was a hot summer night, expressed their displeasure about being in the institution. Undeterred, Prosecutor Gants personally convinced the witness to cooperate with the government. Regardless of the circumstances, Justice Gants can be counted on to do the right thing. He is a credit to himself, his family, and the legal profession. I am proud to call him my friend. Thank you. Anybody like to see the photograph?
law clerk, former student, Judge Gants at New England Law School.
Good morning, Lieutenant Governor Murray and counselors. Thank you for the privilege and all the support. My name is Andrew Kennedy. I graduated from Northeastern University School of Law this past summer, and I'm currently clerking in the Superior Court of the Commonwealth. I've been lucky to get to know Judge Gants as a supervisor, professor, and mentor. I greatly admire Judge Gants' generosity, kindness, patience, and unflagging loyalty to his family, his students, and his profession. He always gives the utmost of himself with humility, compassion, and a strong sense of duty. I first met Judge Gants as a student intern during the summer of 2006 when he was sitting in the business litigation session. Later, I completed 3 courses he teaches at Northeastern University School of Law: Advanced Criminal Procedure, a seminar on balancing security and liberty, and civil motion practice. I was a little nervous before interviewing with Judge Gants for my student internship, probably not as nervous as I am right now. However, he immediately put me at ease with jokes about my resume. He asked me a lot of questions, and I was struck by his curiosity about me as a person, my experiences in the Peace Corps, my family, and my plans for the future. I had expected questions on legal doctrine or items on my resume, and was surprised that he asked so many questions that appeared unrelated to the law. But now I realize that he was trying to get past my resume and to get to understand me as a person and to see if I was the kind of person who would take advantage of the opportunities offered me. Judge Gants' courtroom was a great place to work. He treated everyone, law clerks, assistant clerks, court officers, and judges, with respect and consideration, and earned the admiration of everyone who worked for him. Judge Gants also has great respect for the history of the Superior Court as an institution, and for all of those whose efforts have made it the success that it is today. In his court, everyone contributed. Although it was only a second-year law student with little experience, Judge Gants always made me feel like my opinion mattered, and often asked me how I viewed the cases before him. He helped me to see beyond the legal issues to better understand the nature of the dispute, perspective of the parties, their needs and desires, and the policy questions behind the legal argument. When I was stumped, which was quite often, he would laugh and say, "It isn't easy." But Judge Gants is a great judge because he gives it all in every case, and that is never easy. During the summer of 2006, when family concerns drew Professor Ramirez away from her teaching duties at Northeastern University School of Law, Judge Gants stepped in and taught courses that she had been teaching. Despite the short notice and obviously difficult circumstances, he taught advanced criminal procedure with passion and insight. He brought every student into the discussion, having us stand and argue opposing positions on issues of law. Nobody sat down discouraged, only challenged to do better the next time. He pushed us hard and was always supportive. More than just teaching us the law, Judge Gants made students appreciate their responsibility to strengthen our judicial institution through professionalism and hard work. Judge Gants also made ethics a central theme of his seminar, Balancing Security and Liberty. The course highlighted the changing historical circumstances within which the law exists and informed us about the need to protect the public welfare without compromising our fundamental rights and liberties. His even-handed analysis challenged students to find ways to guard against the very real threats posed by international terrorism without compromising their values. It is a testament to his effectiveness as an educator that in addition to learning the law governing this difficult topic, students learned a great deal about their shared American values. The last course I took from Judge Gants, Civil Motion Practice, gave students a chance to argue motions in front of the civil judge. He understood that students might be anxious speaking in public, and joked with and cajoled us to relax and do our best. By the end of the course, nervousness had given way to confidence, and many students genuinely enjoyed the challenge of oral argument. The final exam took place in Judge Gants' courtroom in the Superior Court, and if you didn't know better, you might have thought some of the students were practicing attorneys. Judge Gants is exactly the type of person that citizens of Massachusetts want and need on the Supreme Judicial Court bench. He takes time to listen and understand, and has a real gift for expressing difficult issues in terms that are easy to understand. He's a man of integrity, honesty, patience, and most importantly, humility. He will make a tremendous addition to the bench of the Supreme Judicial Court, from where, in a different way, he can continue to teach the law. Thank you.
Oral argument was excellent. Thank you. That's David Meyer, the former chief of the Suffolk DA's Homicide Unit.
Governor Murray, members of the council, thank you for the honor and the privilege to appear before you this morning. My name is David Meyer, and for about the last 10 months, I've been a trial attorney here in Boston at the law firm Judical. For over 20 years before that, I had the privilege of appearing in various courthouses, first in Middlesex County, and then for the last 12 years here in Boston and Suffolk County, as a trial prosecutor. In the Suffolk County DA's office, as the chief of the homicide unit, my business day in and day out was to go into the Suffolk County courthouse and, in addition to trying my own cases, to supervise and observe other attorneys in the district attorney's office as they prepared cases and tried cases in front of members of the Superior Court. As you know, a courtroom is a place where all of the litigants in a public forum gather, both prosecutors, defense attorneys, victims, families, witnesses, police officers, and defendants. In the context of a murder case or a homicide case, emotions run high. On one end, there is the victim's family. They've lost a loved one. On the other hand, there is a criminal defendant whose liberty is at stake. There are prosecutors, there are defense attorneys, there are witnesses whose lives may be in danger. There are police officers. There are 12 jurors, 12 citizens who will follow the facts and follow the law as given to them by the judge. I know from my personal experience on each opportunity that I've sat in the back of a courtroom and observed Judge Gants preside over a homicide trial, that he exhibited each of the qualities that the previous speakers have spoken to. The last case that I had on behalf of the Commonwealth of Massachusetts in the District Attorney's Office was a very extraordinary case. It was an extraordinary case for me personally. It was an extraordinary case, I suspect, for Justice Gants. Because that was a case, Governor Murray, members of the council, in which a defendant was being put to trial, I believe for the first time, as the second defendant in a case in which a young man had been previously convicted beyond reasonable doubt for a crime, I suggest to you, that he did not commit. A young man, 18 years old, in Dorchester, had been caught in some gang crossfire in 1996. And a young man, 18 years old, from I believe, the island of Barbados, had been killed. And the police had conducted a thorough investigation, and 6 or 7 witnesses had identified someone as the alleged assailant. The case had been tried in 1997, and an individual had been convicted by a jury of his peers beyond a reasonable doubt. The appellate courts had affirmed the conviction, and that individual was serving a life sentence without parole for a crime that he did not commit. Ultimately, in the year 2000 or 2001, new evidence developed that suggested another individual had in fact committed that very crime. And the police and the district attorney's office worked to develop that new evidence, and ultimately the individual who was then serving a life sentence, his conviction having been affirmed on appeal, was released from prison. And in the fall of 2007, about some 14 or 15 months ago, it fell upon my shoulders to appear before Justice Gants to try the second individual who had been charged with that very same crime back in the year 1996. So on behalf of the Commonwealth, I had to prove not only that this individual committed the crime beyond a reasonable doubt, but in essence that the young man who had been identified by some 7 or 8 eyewitnesses, who had been proven for 12 previous jurors beyond a reasonable doubt to have committed the crime, was in fact not guilty. It was an extraordinary challenge for me, and I suspect for Judge Gants it was equally extraordinary. The case was specially assigned to him by the regional administrative judge for Suffolk County. And there were a series of issues that happened before the trial, discovery issues, all sorts of legal challenges, which Judge Gants methodically, carefully, and with respect for all sides, paid careful attention to. My recollection is that some of the rulings he issued on a snow day from his house, sending by email decisions. And for some 6 or 7 weeks, witnesses testified for the government and witnesses testified for the defense. But along the way, the Commonwealth called the individual who had spent some 8 or 9 years in prison for a crime that he did not commit. And he testified and he was cross-examined. And ultimately the case went to the jury, and to make a long story short, there was a hung jury. And there was no verdict. the jury was split, guilt, innocence. But along the way, both the victim's family and the individual who had been convicted, wrongly convicted, had the opportunity to appear before a judge who conducted a courtroom in a professional manner, who was dignified, who was respectful, who was fair and decent, with not just the lawyers, but the witnesses, the man who had been previously wrongfully convicted. After the first case ended in a hung jury, there were a series of post-trial motions before the second trial began. And there were a series of very challenging legal issues that had to be resolved before the case was to be tried a second time. And over the course of several weeks, the lawyers argued in front of Judge Gants, and he made certain rulings on evidence. Ultimately, one of the rulings, based upon the facts, based on the law, was a favorable one for the Commonwealth. And with that, the defendant, the actual individual who had killed that innocent 18-year-old youth, stepped forward and, through his lawyer, ultimately decided that he wanted to plead guilty. And with that, the victim's family, the individual who some 10 or 11 years previously had sat through one trial and a second trial in which a wrong individual had been convicted, observed in a courtroom the actual true assailant brought to justice and plead guilty. I tell you that, Governor Murray, members of the council, not because it was a particularly successful case for the government, but because as the trial prosecutor in that case, in the end, justice was done. The system did work. And the system worked day out, diligently, following the facts, applying the law, being respectful to the government lawyers and the defense lawyers, the witnesses, the victim's family, and the defendant. I wholeheartedly endorse his nomination for the Supreme Judicial Court, and I thank you again for the opportunity to speak on it.
Good morning. Thanks for being here. Okay. What are you doing now at Charlie Wells?
I'm in a trial attorney, practicing law.
Right. Criminal or you do criminal work there? Or you do
A little bit of both. White collar defense and some civil work.
Okay. Were you involved in the golf course case at Charlie Wells? One in front of Judge Gants?
No, it's not.
Okay. Thanks.
Hold it, Council.
Just quickly, I just want to thank you. I've had the honor and privilege of serving with you for quite some time, but mostly observing you in court. And I think that you're kind of one of the unsung people in this area for all the years you spent prosecuting this one type of cases. If you were taken for many years, I was on the phone to maybe go and make a couple of It was a pleasure and an honor for you to work with you. Highly respect you. Your work ethic and your ability to make this speak.
Thank you. Thank you.
Okay. With that, we have signed up to speak in opposition to Judge Gants' nomination, Stefano Picciotto.
Good morning, Judge Gants. Good morning, Governor and members of the council. Besides myself, my daughter would like to say a few words. The reason we are here today is because the selection you're making is an extremely important one. What are you putting in the Massachusetts SJC is a person that is going to be purely the engine of change in the Massachusetts SJC. This is the opportunity that you have. And you have to decide, members of this council, if Judge Gants is the appropriate person. There's no doubt, from the 10 years experience I have had in the Suffolk Superior Court, that Judge Gants treats insurance attorneys with respect. And there is no doubt that he was an insurance defense attorney. The issue, I believe, is a little bit different. I have heard the Honorable Barbara Rouse speak in this favor. Now, what has happened within the last 10 years, which you may or may not be aware of, is this canons of ethics that we so strongly believe apply to judges. And we think as a member of the public, they will have protection because of the canon of ethics. Under a very honorable judge, in my opinion, Judge Liaros, we had canons of ethics, Canon 2 and Canon 5, they were cast in the word shall. Shall is a term of art in the legal system. It means there of imperative mandate. Well, what has happened in the last 10 years? All the shall has changed and has gone to should under the Honorable Barbara Rouse. And under another Chief Justice, they have installed the Honorable Margaret Marshall. Another insurance defense attorney, may I say. So, at this point, I think your inquiry should be, is how is Judge Gants going to ensure that a judge will not give the appearance of impropriety? Before was casting the word shall. In fact, before, what we had is Canon 5. What occurred here this morning, I submit to you, what occurred this morning, although Chief Justice Rouse testifying, was impermissible. Because Canon 5 Section 5A1B mandated that a judge, especially Chief Justice Rouse, could not publicly endorse a candidate for public office. Black Law Dictionary defines office as a position of duty, trust, or authority, especially one conferred by a governmental authority for public purpose. It is indisputable that this council is a governmental authority. The rules have become very loose in the last 10 years. Judge Gants has been a judge since we have a Chief Justice. The rules have become loose. I've been before this body to tell you about all the problems I have encountered under Chief Justice Rouse. The dates get lost, things don't get documented, which have nothing to do with this particular candidate. But what I'm focusing on is that I think the public is demanding a candidate. In 2 years, Chief Justice Marshall is no longer going to be a Chief Justice. And I think the public is demanding a candidate that will take the reign of that SJP, that will bring it back to Judge Liaros. That's what we need. I don't know, with all due respect, that Judge Gants is the appropriate candidate. Thank you for listening. Do you have any questions?
No. Thank you.
My name is Melita Pachado. Thank you for giving me the opportunity to be heard today. I don't know this candidate very well. I guess my concern, and I certainly heard a lot of very compelling testimony about why he would be qualified. I have to say, as a member of the public, who's had a little bit of experience with this process before, I heard very compelling testimony on behalf of Judge Segura. And my experience with that was that he was, as a litigant, he was a terrible fiasco. I don't know how many other people had my experience and weren't notified of the process. I guess my concern, as somebody who wants to see good judges, particularly in the highest office, is who are these people? I don't think that Massachusetts has a transparent enough process. Who are they as attorneys? Not who their friends say, but what were the complaints against them when they were attorneys? What were the complaints against them as judges? I think that we have more transparency about how somebody conducted their business as a dry cleaner. We know whether or not they were a good dry cleaner. I can go with more confidence to get my shirt clean than I can find out how this man conducted business before we put him in the highest court of Massachusetts. I think we know that other states have better laws in this regard. Florida specifically, there's very transparent government in all three branches, the judiciary, the legislature, and the executive. In Massachusetts, the executive says that they're halfway exempt, the judiciary claims they're totally exempt, and the legislature made themselves exempt. I think what we need to do is adopt the Florida standards so we know as members of the public that the judges that we have are actually good judges, don't conduct trials with jurors wearing Halloween costumes, and I heard Barbara Rouse talk about how fair and impartial and how much integrity there was in the process for Judge Sikora, and what I realized with Judge Sikora is that he would meet ex parte with plaintiffs to a litigation and deny that the meeting even occurred, lie away with lying about it even though the admission was in deposition. So I have to worry a lot about, I know there are many members of this council that are very dedicated individuals, but I also know that there are many members of the body that don't even bother to show up. There are like phantoms, come in late, and so I want to make sure that we have a system in place that the public knows, that we don't have to trust that this board is going to do its job, that we know we have the right people. So I ask Lieutenant Governor to support the legislation that I filed, which adopts the Sunshine Bill, so that Massachusetts residents can have a transparent and accountable government in all three branches. Thank you very much.
One more question. Have you ever, Mr. Machado, have you ever observed Judge Gants in court?
That's my point. No, I have not observed Judge Gants in court. My concern is
So you're not here to question his integrity, his temperament, his demeanor, or his legal skills. You're not here to question any of those. You've never observed.
Well, I don't know what's under the rug. That's why I'm saying here.
You don't know anything to question.
I would like.
I understand, but just answer my question. If you could, help me out.
I think I did.
Okay, so you don't know anything. You're not here to question his integrity.
I think I am by virtue of questioning the process by which you've been nominated.
Even though you've never observed him in court. No further questions.
Thank you for your testimony. I just want to say that there is no similarity between Judge Sikora and Judge Gants. Any judge that would allow people, as Judge Sikora did, to have a jury dressed in costumes to increase a traffic post should not be there. And I voted against him. I'm proud of that. But I don't like to see the same two people put in the same sentence because there's absolutely no similarity.
I don't mean to do that. I guess my concern was the people that were speaking on his behalf and the fact that particularly on Barbara Rouse promoted that sort of behavior up to the second highest court. I think that there's an embracing of that sort of erosion of judicial ethics. I think that it's not Melita Pachado complaining about it. It's the Monin report complaining about how Massachusetts residents go to court expecting that they're going to get prompt, efficient, and courteous justice, and in fact, they get the opposite. I think, you open the paper and Howie Carr says that we have a judiciary that is grotesquely corrupt, and I know it because I'm living it. So I worry about the people that are in power that are creating the system and not knowing what's under that rug with a candidate who seems to have a very lovely family and who I don't have any personal animosity against. I've lost my trust, and I think we need to have, and I think a lot of people have lost their trust, and I think we need a system that doesn't rely on such misplaced trust anymore. Thank you.
I appreciate the testimony, but I just want to say that we could go on for an hour about other things that really more severe than costumes that he allowed. So I just wanted to make that very clear. Thank you.
Thank you.
I just want to thank you and your dad and others for coming forward, because I know it's difficult to come forward, especially for these type of hearings. I would like to say, how did you know about this hearing today? Did you see it in the paper?
Yeah, I heard about it, yeah.
And about a month ago, I recall, is when this nomination came due, and so we purposely have the hearing a month later on this important nomination because we wanted to get that word out. And so in the course of the past month, it has been publicized in the papers. I know in my district, it is throughout all of the local media. So people do have an opportunity to come forward, and as part of this process, we do reach out, and it is very well publicized. So it is our intent and our duty, and what we do is to get information about a particular nominee. So I understand your particular frustration because we have heard about them day in and day out, but I do believe people have a fair opportunity to come forward and voice their opinions and their experiences of a particular nominee, including Judge Gants.
I appreciate your time.
Thank you. We appreciate
Thank you.
both of your thoughts and input on the process. My understanding, I just want to, for information purposes, note that there is a written exception in the canon of ethics, from what I understand, relating to Judge may be a witness to provide information on their nominations to the bench. So I just want to get that information out there. Is there anyone else, Mr. Cronin, that submitted a... No. At this point, I'd invite, welcome Judge Gants to make a statement.
Thank you, Governor, members of the council. I was profoundly honored to be nominated by the governor to serve as an associate justice of the Supreme Judicial Court, and I am equally honored to stand before this council today as you consider the question of my nomination. I also appreciate the time and care that each of you have taken in preparing for this hearing, and I look forward to answering any questions that you may have as best as I can. I find it difficult to talk about myself, and I am very grateful to my witnesses for taking some of that burden off of me. I would like, however, to take a few minutes of your time to tell you something about the people and the experiences that have placed their imprint upon me. I was not born into a family of lawyers. My dad sold wine, and was greatly admired in the wine industry in New York for his knowledge of wine. If you ever heard him explain how, in a blind tasting, he could discern from the taste of a particular glass of wine that it had come from a vineyard in Chile, you would have seen a power of deduction that would have impressed Sherlock Holmes himself. My mother worked first in a local clothing store and then spent the last 20 years of her working life as a teacher's aide in her local school. She would certainly have become a teacher herself had she been able to go to Hunter College in New York City, where she was admitted, but instead she needed to work in her mother's clothing store to help make ends meet during the Depression. My older brother and I shared a bedroom in the former apartment in which we lived. He was plagued as a child by asthma, but by sheer determination and strength of will, managed to break the high school track record in the mile in his senior year. Now that you know that I am from New York, let me put to rest those scurrilous rumors. I am not and have never been a Yankees fan. For reasons not easily understood, since the Dodgers had left Brooklyn when I was 3 and my brother was 7, we were Dodger fans. He kept the Dodger scrapbook containing every news article in the Daily News and New York Times about the Dodgers from 1963 through 1965. I kept the autograph collection, which grew to include such heroes as Sandy Koufax and Roberto Clemente and the less well-known Hall of Famer Max Carey, who with his signature gave me the sound advice, "You can't hit unless you swing." I joined Red Sox Nation around 1975 when Jim Rice, now a Hall of Famer, and Fred Lynn joined Carl Yastrzemski in the Red Sox outfield. I studied economics at Harvard College, but developed an interest in criminology in my senior year. I spent my senior year writing a thesis on the incapacitation effect of criminal sentencing, which examined how longer criminal sentences would affect the crime rate. And I told the professor for whom I worked part-time that I was going to law school rather than pursue a doctorate in economics. She said, "You're going to profit maximize, aren't you?" That's how economists talk. I tried to persuade her that I planned to pursue a career in public service, but she was skeptical. Having now spent all but 6 of my 28 years after law school in public service and hoping to spend the next 16 doing the same, I think it is fair to say that I have not profit maximized. After law school, I worked for a great judge and an even greater human being, Federal Judge Eugene Nickerson of the Eastern District of New York. It was while working for him that I decided I would like to become a judge. Every day, Judge Nickerson carved out a corner of Brooklyn where every person receives a fair hearing and a fair shake. where every litigant and lawyer was treated with respect and dignity. He was blessed with great wisdom, but perhaps because he was so wise, he was willing to recognize the possibility that he might be wrong. He would encourage his law clerks to disagree with him if he thought a first draft of the decision was wrongly decided, telling us that if we voiced our disagreement, only two things could happen, both of them good. Either he would be right and he would be wrong, and he would be saved from making a mistake, or he would be right and we would be wrong, and he would be able to strengthen his decision by clarifying the points that had confused us and by adding the points that had persuaded us. After clerking for Judge Nickerson, I served as a special assistant to Judge William Webster, who was then the director of the Federal Bureau of Investigation. Judge Webster taught me the importance of rigorous analysis, of a need to question assumptions, to ask how we know what we think we know, why we think. I learned his lesson so well that at my farewell breakfast, he said that I was the hair shirt of the FBI, referring to the rather uncomfortable shirt made of goat's hair that monks wore to prick their own consciences. He meant it as a compliment, and I took it as one, although I know that not everyone would see it that way. I would like to think that metaphorically I keep that hair shirt in my closet just in case I need to wear it. Then United States Attorney William Wells brought me to his attorney's office in Boston. I began by prosecuting firearms and arson cases. I ended by prosecuting public corruption. It was there that I saw how elusive is the truth, how things are not always what they seem, and how much hard work is involved in ensuring that justice is truly done. I learned that same lesson when I joined the law firm of Palmer & Dodge and began to represent those who were under investigation. I would like to think that having sat on both sides of the table in a criminal trial gives me a greater understanding of how justice can be accomplished and how it can go astray. It was my former boss, William Wells, who in his last months as governor nominated me to the Superior Court. I cannot tell you how proud I am to sit on the Superior Court, and how privileged I have been to have served with so many fine judges, officers, court clerks, and court officers, including those who sit by my side today. Maybe somewhere in this nation there's another state so fortunate as to have so many dedicated jurists working in such harmony to provide so high a quality of justice, but I doubt. As a Superior Court judge, I have tried to apply the lessons that I have been taught by my extraordinary mentors and colleagues, to listen with an open mind, to find the facts as they are and never to seek to conceal or change the facts to support a conclusion, to confront the strongest argument that differs from my conclusion, so that I may test the wisdom of that conclusion, draw clearly and understandably, so that my decisions may be read and understood, not only by lawyers and judges, but by the average citizen. I believe that those lessons will hold me in good stead if I were to win your confirmation and become a justice of the Supreme Judicial Court. But I also know that if I were to win your confirmation, I will need to learn many new lessons, because the job of a trial judge differs from that of an appellate judge. As a trial judge, every case, whether it be criminal or civil, is a dispute that the parties have been unable to resolve. As a trial judge, we help the parties fairly to resolve those disputes, whether that be by deciding legal issues that divide them, by presiding over a trial, or by assisting the parties to reach a settlement. We apply the law, we do not declare the law. When the law is unclear, we try to resolve the ambiguity as best we can, knowing that the Supreme Judicial Court will have the final word. The Supreme Judicial Court, however, declares the law, and in doing so, sets the parameters by which future disputes in our courts will be resolved. I will not attempt to set forth in detail my judicial philosophy, but I will provide you with a preview of what I believe. I believe that a statute should be interpreted in a manner that is faithful to the legislature's purpose in enacting that statute, with that purpose being discerned from the language of the statute chosen by the legislature, the legislative history, and the historical context. I believe that our Massachusetts Constitution was meant to endure for many generations, and therefore must not be seen as a dead letter, but as a living, breathing document which, like every species of being, must adapt to changing circumstances and to our evolving understanding of the meaning of due process and equality under the law. I believe that in declaring the law, whether it be statutory, constitutional, or common law, the court must draw clear lines so that the law can be understood and administered in the real world. And I believe we must ensure that our justice system works, not simply in theory, but in fact, and that it works to provide actual justice, not simply the illusion of justice. With that, I thank you again for your very careful attention, and let me now invite your questions.
Thank you, Judge.
Starting at one, Lieutenant Governor?
There are no questions on the,
I didn't know you were starting at one, or...
okay, yeah. Sure.
Thank you, Lieutenant Governor. Thank you, Judge Gants, for your testimony, and I really appreciate that of all of your witnesses. It was very consistent, certainly, and heartfelt, and speaks to your great experience and wisdom. And that has been echoed throughout, as I mentioned to young lady, Mr. Soto, who said, you know, how do we get enough input? And certainly, I have done that as the other counselors have, and that continues to come out. Your intellect, your work ethic, certainly, and of course, your experience. The one thing that we do try to find, though, is what people have to say if there might be something not as positive. And of course, that is always the case today. We expect the praise and good words to come out, and they certainly have, and they are sincere and consistent and true. But what did come out, and I think we spoke very briefly about this, Judge Hanson, we talked about a little bit more at the hearing, was we heard from the prosecutor earlier today, but many of the prosecutors that I spoke to on the criminal side, or civil when it comes to sexually dangerous persons, took issue. They are not here today, but they did take issue via sharing information with me or their concerns and questions. And that had to do with a number of cases, and I'd love you to take me through some of them, and we'll talk about a few of them, and you know, how you came about some of the not just the decisions, but the methodology that you did. And if you just bear with me a second, I think one of the questions was, first of all, you said faithful to the legal definition, you know, of the law that are out there. And one of the questions that came out is on sexually dangerous persons civil commitment hearings, that in terms of the definition whereby are they likely to engage in sexual offense, and certainly this is not an easy situation. You know, in my district, there's been a lot of discussion and controversy about some of these hearings, and I did not want to be in a position to have to review that, although I do know the prosecutors take that very serious as well. It's not like they're bringing these cases up, very small percentage of those cases, and those people get recommended to these civil commitment hearings, as you know. But where it says likely to offend, I believe it was in the Reese case, perhaps, that you would better recollect, certainly than me as you lived it, that in the probable cause hearing, that actually I'll get to the change, but there had been the Rodriguez case whereby a written testimony by Dr. Carl Hansen was presented versus the live testimony on the Commonwealth side, and we felt very strongly about that testimony of Mr. Hansen, and we did in fact rule no probable cause to keep Mr. Rodriguez in. I guess a few weeks later there was a Reese case whereby I believe the defense did not have that Hansen information, and the concern that many of the prosecutors had, and the question that I have is, would you consider that commonplace to go and get the evidence that was brought forth for the defense in another case, and as the judge present that information to the defense and say, here, use this? I mean, I'm paraphrasing, and I certainly appreciate your input, but maybe you could comment on that.
Yeah, I very much appreciate the question, because I know it's a matter of concern. So to do so, if you bear with me a little bit, just to provide you the background that you had mentioned. First of all, for those of you who may not be familiar, as Counselor Fiola was speaking about sexually dangerous person cases under 1999 law, which was passed. It addresses those who've already been convicted of sexual offenses and have already served their time. So these are individuals who've already completed the sentence that has been imposed by a judge for their sexual crimes. They are about to be released, and the question then is whether or not these individuals are so dangerous that they must be civilly committed for either 1 year or to life because of the danger they pose to the community as a result of their personality disorder or mental abnormality. Essentially held in custody for trial. Pragmatically, that trial probably would not occur for anywhere from 6 months to a year. So the result of finding somebody sexually dangerous at a probable cause hearing is to hold that person who's already finished their sentence for anywhere from 6 months to a year. So these were all the uncertainties that were before me in spring when I was presented with the Rodriguez case and then the Reese case. In the Rodriguez case, what happened is the defense counsel, Mr. Farrington, offered into evidence a series of articles by Dr. Hansen, who was recognized as the leading expert in the field. Dr. Hansen had done a study of studies, that is, he had studied all the various studies of what the rate is of sexual recidivism, the rate of reoffending by persons who had been released from custody. And as a result of doing a study of studies, he gathered up about 17,000 individuals, and he had done a very careful analysis of what the risk is of recidivism for these people, what characteristics make them more likely to offend, and a whole series of studies that he had done. Mr. Farrington, defense counsel, offered that. In the Rodriguez case, the government had no objection to their admission, and they were offered, and I read them as part of the evidence in the case, and they were, after all, the empirical evidence surrounding what is the level of dangerousness, what factors make somebody dangerous. So I read them in the Rodriguez hearing, and I was in the midst of writing my decision in Rodriguez when the Reese case comes. In the Reese case, at the hearing, it's a different defense counsel and a different prosecutor. And I had read all this information about what the literature says about sexual dangerousness. I knew it. I could have, in theory, said nothing, and just as a judge is not supposed to do. If a judge is dealing with a mortgage foreclosure case and happens to have majored in economics and knows about the law of mortgages or has read studies about them, the judge is not expected to forget them or ignore them. I could have essentially used this as part of the background of that a judge does in terms of studying the literature about sexual dangerousness. I thought, it was found to be an error by the Supreme Judicial Court, I thought it was fairer rather than just say, essentially know it and not mention it, that I said to the prosecutor, listen, I've read all these articles. They speak about the issue of what the true dangerousness is of various offenders. You can't separate this issue from that. I asked the defense counsel if he wished to offer it. He said he did. In this case, the prosecutor objected. Previously, they had not. And I said, well, no earlier objection, but I will give you how much time do you need to offer me any literature which you think I should read. And I gave her the time that she asked for, and indeed she submitted, I think, 3 articles, one of which was by the same Dr. Hansen, who was, and they were much along the same lines. So I came to the view that it was fairer, as opposed to knowing this and acting upon it, I thought it was fairer to have offered to tell the parties, listen, I just read it, I can't ignore it, I can't ignore what my knowledge is about the literature concerning sexual dangerousness, and I'll give you a chance to respond. That was found to be in error. It's not something routinely that I do, but the other thing you should understand is that the sexual dangerousness hearings are really a different animal from almost everything that we do in the criminal, and certainly in the criminal sphere. Because in the criminal sphere, the question is, did somebody in the past do something? And therefore, the evidence is focused on whether that person did that thing, whether that person did that thing with the required criminal intent. In a sexual dangerousness hearing, the question is, will that person do something in the future? And therefore, there's a much broader range of evidence, because you need to know a lot about a person to be able to consider whether that person in the future is likely to be committing offenses, that a whole lot of people have been studied to see which characteristics of people make them more likely to was part of that. So that's I know it's a very long-winded answer to your question. The answer is, do I do it routinely? Absolutely not.
I do find that, troubling, as did the prosecutors that spoke to me, because, again, as a judge, as you indicated, in your canons and so forth, faithful to the law, I didn't see you as an assistant to the defense, but as someone who listens to what the defense brings to you, and then you have to make it based on not your knowledge, because we all bring knowledge of our experiences, and yours are certainly extensive, but is it not the duty of the judge to take the evidence at hand, not the information that you've garnered over the years of
Well, yes and no. Certainly with regard to the particular case, you of course only take the evidence at hand. With regard to knowledge of the literature in a particular area, I don't think we're expected. I mean, if we have read a great deal on a particular subject, whether we have a case involving insanity and we happen to know a good deal about psychiatry, I don't think a judge is asked to know everything the judge knows. So I placed it in the category of background information about this issue of sexual dangerousness that I think would be appropriate for a judge to have used in making a decision, as opposed, certainly if there had been any information about this individual that, well, of course I would never have it, but then it would be...
I don't mean to interrupt you, but in the Reese case, for example,
Right.
They had defense counsel, correct?
Right.
And did you not go and get that information and say, here, use this? I mean, maybe not physically, but it appears to be that is what is told to me that you did. You went and said, hold off, let me go get this information. You should really look at this, because this is good stuff that'll help you. Maybe you use those words, certainly, but is that
I
happened?
think what I did is I said, I've already considered it. Would you wish to offer it into evidence so that we part of the record and gave the other party the opportunity to respond? Again, I thought it was appropriate. The SJC agreed with you. It did not. It is a very unusual circumstance. I did what I did because I thought it was a fairer thing to do as opposed to acting upon information that I may have. I thought it was fair to tell the parties, listen, I've already read this, and to give the other side a chance to provide me with literature that would be different. As it turns out, the literature they gave actually was not really very different on the issue. I thought it was fair. The SJC agreed with you and thought that it was error. So I certainly abide by their view. But my view of it was not to help the defense. My view of it was to be fair to all sides and not to act upon information that the parties did not have a chance to themselves review, and to be fair, frankly, to the prosecutor to give her a chance to present articles that could be to the contrary.
That you wouldn't have to do that if the defense didn't have the articles because they did not.
Well,
I mean, just happened.
yes, I mean, I guess that what I would say to that is I still need to determine whether or not it was likely. And so what you would be asking me to do is to evaluate the issue of whether it was likely without considering all the information that I learned about these 20,000 offenders in terms of what factors make them likely to reoffend. So, in theory, I could have essentially tried to divorce myself from all that I had learned about sexual dangerousness, which factors make somebody likely and which make them unlikely. But I think it's very hard for anyone to do. And again, I came to the view that it was fairer to be upfront with them and say, I've read it, it's part of what I know now, and to give them a chance to respond. It was really not designed to help or hurt anybody. I thought I was being fair, frankly, to the prosecutor to be candid and say, I've already known this, I've already read this, I can't reasonably put it out of my mind, and give the prosecutor a chance to furnish me with different information. Again, I was found to be in error, so I certainly
the prosecutors were not happy about that, obviously.
Well, this prosecutor was not happy. Again, the previous prosecutor allowed that to come in without objection. So one prosecutor said no problem that they come in. This prosecutor, a few days later, thought differently. But yes, I'm sure this prosecutor was unhappy with me.
Now, continuing on with the sexually dangerous person, if you could for a second, Judge, let me just get my notes here. The language of that law and those guidelines did not originally include things like within 5 years, and I know that's come up and that's been documented in memorandums and information. What prompted you to decide to...
Using the statute, it was not clearly understood what it meant. The definition of likely did not come from the SJC until more than a year and a half later. It was in December of 2002, but this is in April of 2001. It was not until December of 2002 that the Supreme Judicial Court in the Boucher case defined likely, and I brought part of that. Let me just read 2 sentences from it because I think it's important to understand that I think most judges, as I did, thought that likely meant more likely than not. And that, again, was found to be an error by the Supreme Judicial Court. We read from Boucher, which was not decided when I had Reese and Rodriguez, was decided a year and a half later. The SJC said in Boucher, likely is not defined in General Laws, Chapter 123A, nor is it understood to be a term of art requiring a specific and limited interpretation. It went on to say, we conclude that something is likely if it is reasonably to be expected in the context of the particular facts and circumstances at hand. So that's what they said likely was to mean. I think you can understand how that was not obvious to myself or to other Superior Court judges at the time that is what the SJC would end up saying likely meant. So we were all struggling to figure out what likely meant, and frankly, many of us were seeking to put likely into a framework that we know. We know more likely than not. That's what we use in every civil case. So what I did, again, trying to interpret what the statute meant, is to say that likely meant a person is more likely than not to commit a sexual assault. So that's part of what I did. Now, the statute says that when you look at the definition of mental abnormality or personality disorder, it speaks about having a psychological condition that essentially compels the person to do something.
Although, Judge, I think that interrupting the rule, like anyone who's molesting sexually a 6-year-old or an 8-year-old or repeatedly over a period of time has that sometimes deficit. And I don't write mental books, but anyway.
The actual literature is somewhat surprising in that the rate of sexual recidivism, even for child molesters, although obviously considerable and it may vary by individual, is not as high as we think it is. It's not in the realm of 70-80%. It's actually lower than that, and so there are people who engage episodically in this conduct but may not. So it's and that's part of what this data illustrated, is that what we think we know about sexual dangerousness is not necessarily supported by the data. But part of what I was trying to do is to make a definition which allowed us to use the data concerning sexual dangerousness. What that data essentially does, and it's what's called the Static 99, which is what Hansen presented, and is now used by the Sexual Offender Registry Board to evaluate dangerousness when they do level 1, level 2, level 3. They use the Hansen data to categorize somebody as a level 1, level 2, or level 3 offender. I was trying to have a definition which would allow the data to be used. The data differs depending on what length of time we're speaking of. If you were to ask the question, what is the likelihood that somebody will be convicted of a speeding violation? Well, for each of us, if we say within the next year, that's going to be much lower than if we say within their lifetime. So the issue of how dangerous somebody is really depends upon what length of time we're talking about. And I thought that if we had some period of time, it would allow us both to recognize that this mental disorder or this mental abnormality or personality disorder is supposed to be so severe, that so compulsive, that somebody would have to, in a reasonable period of time, be likely to commit it. And if we gave a fixed period of time, we could then use the empirical data to be able to place that person in a range of dangerousness. So that's what I was seeking to do, was to basically have a definition of likelihood that allowed us to use the data on sexual dangerousness so that we could categorize people in terms of how dangerous they were. Clearly, this law was meant only for the most dangerous sexual offenders. We don't have room to put everybody who's ever committed a sexual offense at Bridgewater. We'd be filled up within a year. So it's really meant for the most dangerous. What the Hansen study does and what they do for level 1, level 2 is they categorize who is the most dangerous. And I thought that by using a period of time, we could accomplish a definition that judges understood, juries understood, because juries would have to apply it, and that could use the data. And again, I was found to be in error as to that. But that's what that's at least what was my frame of mind, given the state of the law back then.
And you can see why the prosecutors, again, in terms of sexually dangerous person, I know you've been dealing with business litigation the last 4 years, but was concerned and have those concerns.
Right, I certainly understand that, and I also acknowledge that the SJC reversed me. So on that, the SJC had a different view. I, of course, followed that view after it came down. But I do ask you to consider that the law was really was developing. It was really at a very early stage in that spring of 2001. That's why so many of these issues were so difficult, because the standards really had not yet been articulated by the appeals court and by the SJC.
I do have to go, but you know what, do you want me to move on a little bit and then come back? I'll yield and allow you to continue.
Come down. Councilor.
If you excuse me, Judge Grant, as a matter of personal privilege to depart from this hearing, today as we meet the governor and our constitutional officers are attending a funeral for a hero, Boston firefighter Lieutenant Kelly. And as a citizen and as a firefighter's widow, I would ask that we all stand in silence or in silent prayer for the leave of her Lieutenant Kelly. Clear one thing up with the widow family. First of all, this hearing was publicized by statute that required the law to go over December 11th. And the Zudos were going to attend December 11th. And they have come when there's a week notice after the nominee is appointed and announced by the governor. And the governor did announce this appointment December 1st. So I just want to clear that up. It's a pleasure to see you. It is indeed a counselor. I am very gratitude to you, and I want to thank you for all the time when we met and many times when we talked right up to last night, and I appreciate that. I have some questions prior to you being judge. How many criminal trials did you first see?
Did I first see? On the prosecutive side, I would say in the ballpark of about 20 federal prosecutor. On the defense side, I think on the defense side, whatever it was as first chair, I think there were about 3, otherwise I could be wrong.
How about civil trials?
Civil trials, there were fewer, and I think there were none, of course, at the attorney's office. I only did criminal. I think there were 2 or 3 on the civil side which reached trial. There were rather administrative hearings which were similar to trial-like, but in terms of civil trials, it was, I think, 2 or 3. But again, I didn't count them before I came. I think that's in the whole time.
Did you ever represent individuals like criminal defendants?
Oh, yes, of course. I represented individuals who were indigent and individuals who could barely afford to pay. Some who could actually afford to pay, but I do remember for at least one of them, the person who actually was acquitted before Judge Toro, he really couldn't afford Palmer and Dodge. We did everything we could to make it affordable, including having them bring his Xerox machine to the conference room and having his daughter I've represented indigent defendants, I've represented persons who could barely afford to pay, I've represented some who are corporations who could afford to pay.
Well, I had a question here, did you do any pro bono or public defender work, for that? An individual plaintiff also?
I'm sure the answer is yes, although I can't, well, yes, of course, yes, there were some.
All right, now, let's get after being a judge, becoming a judge. How many jury trials have you conducted?
As a judge over 11 years, I would say it has to be over 100. I'd have to go back over my jury instructions on my computer to do that, but a lot.
And how many decisions have you made?
There are in Westlaw, as of December, I think, 228. Those are only the published decisions. All of my BLS decisions are published in social law, and I only publish probably 1 in 10 of what I write. So for that, I would have to say in the thousands. Some of them are short, but even longer decisions, I would say, would be in the thousands.
So how much of this work is dedicated to writing?
It varied when I went to the BLS. In the BLS, we try cases, but most of our work is motion-type work. When I'm on trial all day, it becomes actually very difficult to write all the motions because the cases are most of them generally complex. So in the BLS, I did a great deal of writing. I think Chief Justice Rouse is in the ballpark of saying about 100 pages a month. It varied, of course, depending whether I was on trial. I wrote a little bit less. I would write up. I think most judges would say that I wrote more than the average Superior Court judge, and I think most of them would probably say I wrote more than I ever should have.
Just a ballpark figure, what is your overturn rate on this appeal?
Very low. I never keep track. When, I do note that as a judge, we make thousands of decisions, not only those which we write, but for every trial, we're making evidentiary decisions. We're ruling on discovery motions. We make decisions every day, and a whole lot of them may not seem terribly consequential, and some of them may come back at us. I've been reversed more than I would like. But I don't think I really have not kept track. If I were to, I probably should not guess, but because a lot of these decisions are common, they're 128s, and they're only a page long to affirm, I would say in the ballpark of about 5% in terms of written decisions. But that's a very rough ballpark, and somebody could go back and do the research and find that I'm wrong. But I do get reversed. I am in error at times, and then told so by our appeals court and our SJC. But fortunately, not that often. And I also think that most of the reversals that I've had have not been really for as much for errors of law as for areas of law where there is uncertainty and that the law has been developed. There really haven't been very many in which they said there was this case and you just missed it.
I'm not a lawyer, so I have a question that I had noticed recently, that you had an injunction issued against the mortgage foreclosures, and this was upheld. What do you say to the criticism that people should be held responsible for their mortgages and what they sign?
And people should be held responsible. And the Fremont decision, which you're making reference to, and then later the Regional Block decision, expressly says that. What the decision, in a nutshell, says is that both sides bear responsibility, that there is in the common law this concept of predatory lending, basically providing a loan which the lender reasonably knows the borrower could never pay and would be due to foreclosure. And that is predatory lending for a lender to do that. Those decisions have also also said that, and I said it quite clearly, to the borrower, don't think that means the loan is void, doesn't mean that you don't have an obligation to repay. What it pragmatically means is that that is a loan which reasonably should be modified so that it can be made one that a borrower reasonably would be able to repay. So the issue really is modification. I made it very clear that the mere fact that a lender is engaged in predatory lending does not mean that the borrower is off the hook, but pragmatically it means that that is a loan which the court would say should be in some fashion modified.
This is something very personally important to me, and I have to ask. Talking about independence on a board, and particularly the highest court in Massachusetts, is so important. Is there any value to you in a dissenting opinion of this SJC? And if so, what is the value of dissent?
I think there's great value in dissent. I think you and I even spoke about the late Justice Martha Sussman, who was a good friend of mine, who in her day probably did more than her share of dissents. I think her dissents, everything she did was very, very carefully reasoned, and I do think that the presence of dissent does keep everybody on their toes and fair and honest. So you remember Justice Brandeis from the U.S. Supreme Court. I think he was known as the great dissenter in his days, and a fair number of those dissents are now, which we forget that they were dissents, that they appear to be part of what we understand to be the prevailing law. But I do think there is an important role for someone to dissent when the issue properly is what is believed to be an important dissenting point.
Now, Judge Bosman, I have the pleasure, like you, she was in my district, and as you know, I resided over there, and we miss her, and she's just wonderful. She's a wonderful person. This is the most important question to me. Can the public count on you to stand up to the majority, to be the minority when you believe the majority is wrong?
Well, I mentioned in my statement that even before I was 30, I was referred to as a hair shirt. The FBI, as you may expect, is not the easiest place for a kid pretty much out of law school to be speaking his mind and saying certain things don't make sense, so we should rethink certain things. I did it then when I was 28, 29, and I don't think I've assaulted that much since. So I do believe that the SJC is a collegial body and should be, but I have no reservation about my ability to stand on my own when I think differently from my fellow justices.
Now, what judge would you model yourself after? Is there any judge?
Judge Nickerson is the judge not only who I would, but I do. I think of him all the time. In fact, actually, he passed away in 2001, but I was thinking of him so much that I actually Googled him trying to find his daughter, who I know had married a Venetian gondolier. And I had actually had seen them when we were in Venice, and I was trying to find them, but of course the name was too common. What I did discover during my Google search is that he is a direct descendant of John and Abigail Adams, which he never told us when I was clerking for him. So I did not realize that he was a direct descendant of the family. So that's as close as I get to the author of our Constitution as having clerked for Judge Nickerson for that year in 1980. But he's the one who I think of most on.
Now, we spoke about this, about sending letters to the JNC, and you said that you didn't and you weren't invited to do so. And I just wanted to put that on the record.
I'm sorry, to JNC, the letters were sent. I did encourage all my friends to write you, but it was routinely done that you would write letters to the JNC.
You
They, at the end of the first process, they say you can have 10 at the part of the routine process. And so to them, they got their 10. I didn't, when it came to you, seek to inundate you with letters on the basis that you may have gotten. I really did not put together any particular effort to have.
Well, I had asked the JNC to have any letters of our nominees this past year. The winner, I don't want to, interfere with the confidentiality of anyone that did not get the position. And I refuse, and that's why it's important for me to know, because I think that should be disclosed to the council and to the public. And because any time that I know other councils and myself, any time I get a call to recommend for someone that knows the nominee, I welcome that, and I publicly state it on the record at the meeting. And in fact, Judge Gabbard was the first person to call, and three people in particular that I respect called me: Judge Gabbard and Judge Neal and Judge Reed. And that's a public process to let people know. But to me, to just have the JNC keep those letters of endorsement and not make it public doesn't seem appropriate when that judge was nominated and the country is going into a court to know who those people are. I think the public has the right to know. So I appreciate that. But I have to mention, you're going to be in the Governor's Council, how can we say, book of records in 63 days after the governor has nominated you. So that is too bad. I regret that, and I'm glad that your mother, she must be so proud today of this historic time, and that she was able to rearrange the date that she was coming December 11th, and for her daughter, Rachel's coming from college, and rescheduling, and Michael, and Mrs. Gants, and I want to thank you. I'm sorry for this delay. And thank you very much for your very, I think that I have to say, I always say I don't have a poker face, and